We are live. We are live. Welcome to College Football's Peek Around the Corner with your host, Greg Pflugar. We cover everything in college football because we love everything in college football. And if you do as well, please subscribe to our channel. Smash the like button if you like our content. Share the video with your family and friends. If you want to support this Rebel Outpost College Football YouTube channel with a donation, just hit the $sign where you make a comment and we'll get to you super chat as quick as possible. Welcome in. Welcome into the studio that sits on the very corner of Keith Jackson Parkway and Kurt Gowdy Avenue. Do not be afraid. Do not be afraid to be a legend. With the chat room, with the comments, with the phone calls later in the show. All rise. Court is in session. Mecklenburg County, North Carolina, Florida State versus the ACC. And I'm sure you all been doing what I've been doing this morning. Watching Doug Rohan. He's in the courtroom. He's been a guest on the show. He called in. He's been a guest on the Big 12 Mafia show and a bunch of the Old and Garnett with VC Knoll, and he's been on a lot of shows explaining to us all what is going on. Let's just go straight to him right now. We'll backtrack. There is going to be a break here coming up. Florida State had an hour. Now the ACC has an hour. I think there's going to be a break right after ACC is done. Or we're going to go to ESPN, and they're going to get about 15 minutes. Then we're going to go to a break. I know there's a break coming up. So it was a very difficult decision. When do we go live this morning? Because honestly, as you all know, I really can't. I can't add to any of this. I barely understand any of this. But this college football YouTube channel is a sounding board. We've got a lot of really smart people in the PATC community who can call us in a little bit here and explain what the heck is going on. Again, the last tweet that Doug Rohan put out, Cooney, who is the ACC lawyer, again focusing on the narrowly targeted deck action. This was 7 minutes ago. Doug Rohan. I do provide a link to Doug Rohan's X account in the description. Judge, is it a reasonable expectation of Florida State that under the Constitution, ACC Constitution, this provision assures them that any litigation against a member like them would necessitate a vote? This is the part that has, that you can tell the judge, okay, well, for me, it seems like the judge is not impressed with the ACC's explanation on how they could deliver December 21st lawsuit in Mecklenburg County against the Florida State Board of Trustees when they did not have a vote, when they did not follow their own constitution. Now, I'm just going to swing over here. Hold on, everybody. Hold on. We also have, I want to thank everybody who's come on in. Skull Ducky, Patrick, Nick Boardman, Rock and Rant, Clemson alumnus is in the house. UNC board is ready to fire AD. Breaking news. Ryan Brooks, Bruce Harris, Randy Taylor, Kyle Visser, my Prof, Gene, Calderon, they're all in the house. Jim Reese, Tumasta, Sheep and Wolves Clothing. Great. Thank goodness I need legal interpretation. Well, you're not getting it from me, buddy. You're not getting it from me. Sheep and Wolves Clothing, you and everybody else in the chat room are 3 levels above this thing. But this is going to be a sounding board. We're going to cover people's reports on it. We're going to cover what you all say. We're going to cover the great phone calls that we're going to get later in the show. That's all I can provide today is a sounding board, a place where everybody can get together at the water cooler, because I'm not going to be able to add anything when it comes to what is being expressed in that courtroom. Thank you for everybody for coming on in. I appreciate it. Greg, do you sleep? Very little. We've been up. I did not know when to come on live. That was probably the most difficult decision I've ever had doing the show. I wasn't going to do 2 hours of reading tweets, right? I want to be able to cover what other people believe. You know, I think we did the right choice coming in now. We'll see. Maybe it was a little bit too early. Expedition Greg, 6 minutes remaining in the 1 hour ACC. First of all, Greg, what is the energy drink? 0 sugar, cherry Coca-Cola. That is my energy drink. Okay, VC No wants me to go ahead and read them. Okay, I'll read them. I'll read the tweets, but I've got no idea. You guys know, I am not, look, VC No knows this. I am not the brightest bulb in the fridge, but wherever I'm at, whatever location I'm at, I do know where the refrigerator is, but I'm not the brightest bulb in the fridge. Rohan Law, Cooney is handing it off to Mr. Lawson. They're the ACC lawyers. 6 minutes remaining. King has 4 minutes remaining. Going to use this opportunity to break for 15 minutes. Catch your breath. Okay, let's start from the beginning. I'm not going to read every tweet. We'll go over the important ones here. We'll just jump around. As what was explained, the judge is going to have Florida State start on a motion to dismiss or stay. Both sides have 1 hour for argument. Then we will follow with motions to seal, with both parties getting 20 minutes each. Then 10 minutes for ESPN 15 minutes estimated for planning conference. So we still got a ways to go, ladies and gentlemen. 10 to 15 minute break is expected for the middle of the hearing. Wants to be done by 1 or 1:30 p.m. at the latest. I'm expecting that 10 to 15 minute break to be coming up right now. Okay, so let's get to this is King, the lawyer for Florida State. He argued the ACC did not get approval to file his suit in December. The court can look outside the pleadings, and we look to the ACC affidavits in the amended complaint concerning a vote being taken in January. If the standing exists based on the vote, the standing did not exist. Again, that is the argument that the ACC did not have legitimacy to file that December 21st lawsuit because they did not do a vote. And in my estimation, and I'm gonna go ahead and open up the phone lines right now. People can call in. We'll hit a few more tweets of Doug Rohan when Florida State was arguing. Then we're going to hit some very important tweets of Doug Rohan when ACC was arguing, and that second half of the arguments for the ACC did not go well in my interpretation. It doesn't seem like the judge was buying what the ACC was selling. The phone lines are open, 763-260-1333. We're going to narrow the phone call scope to just talking about this court case that is going on this morning. Okay. This is King. Early this morning, Florida State lawyer. The ACC states it did not need to take a vote because the initial complaint was not the initiation of a material litigation. The vote was to approve the amended complaint, inclusive of the initial complaint. The ACC is admitting through the attempted ratification that the ratification was required. What does all that mean? I have no idea, except I think it means Florida State is arguing that, look, sorry, guys. We're all over the place here. Florida State is arguing that they needed a vote. They needed to vote. Now let me see here. Hold on. Then near the end of the Florida State's case, the judge asked about North Carolina being the home of the ACC for 70 years. Sources approve her. Decisions were made here, creating the controversy. Why should the case be heard in Florida? Even if I don't agree on the first filed status. Again, the judge is saying, look, even if I don't believe that the ACC did that first filing correct, that status, why should this case not be heard in North Carolina? King, Florida State's lawyer, responds several factors. Favor Florida, including sovereign immunity. Judge interrupts. Why is that an issue in Florida? Florida State waives sovereign immunity in Florida? King continues. Questions of law regarding unreasonable restraint of trade. Who has the capacity to bind agency to the extent North Carolina contract laws applies, Florida State in particular is very similar. This is a problem for Florida State. Judge is making a good point. Ooh, we did have a phone call for a moment. Okay.
Call from
Immaculate.
Mr. Hawkeye, thanks for calling. The floor is yours. What do you think
sorry
so
about
far?
That first call was me. My own phone messed up. I think it's coming down to exactly what we've been talking about ahead of this. All the side talking and things going on by the ACC lawyers. Really, it seems like the judge was just waiting until they got to this part, until they got to the point where they're talking about why didn't you need to have a vote in order to file this complaint.
Yes.
You know, and the fact that they've done it for the amended complaint, the fact that they did it for the response complaint on Clemson, I mean, it just doesn't add to their case. And, you know, they're in a business court. I don't care where it is. Like, is this judge willing to be that blatantly on their side to say, this is acceptable behavior? I haven't thought so from the beginning, and now we're finally getting to that point. And it seems like he's cooking that lawyer enough where he had to tag out and bring in someone else.
Yeah. I'm assuming they're done right now. Florida State is done. This is Cooney. The Florida State states that the BOT never authorized the president to approve the gore. They went in a back and forth on this as well. Because King, the Florida State attorney, earlier in the day said, yeah, we're not, I don't know what the words I should use here, but we're not bounded by, we're not an agency of the ACC. Our president, he didn't even sign the grant of rights. Sources documents, according to Cooney, source documents show the president signed. The warranties provision is each member institution warrants that alone or in concert with another entity has the right to enter in this agreement. But Florida State did bring up the fact once again that it's only the Board of Trustees that has authorization or never gave the president authorization. I don't know how strong an argument that is for Florida State. Probably a weak one. What do you think about that?
Well, if I'm going to come down to, you know, when the president signed or not, if I was Florida State and they did not know about something like, let's say, the 2027 opt-in, I would say it doesn't really matter. The point is moot because he was signing the contract under fraudulent conditions. He didn't know fully what he was signing. Now, if they knew about that, then maybe they'd have to argue these details. But I think the ball's fully in the court now of saying, I don't think this is about a stay. I think this is going to be about the dismissal. I think he's going to dismiss.
Wow.
I think I'm saying the right way because of the ACC and how they filed it.
Mm-hmm.
Right now, maybe, like I said, like the most he might be able to do then is to bring forward the amended complaint as like the new one, and then that would give them a whole new filing date, which gives up the whole primacy thing anyway. So, my opinion, there was one tweet, I don't have it in front of me, from Rohan, who is doing an amazing job. I mean, this is so much. I'm enjoying this right now. I've just been trying to provide some color commentary for it just since I'm watching. But the point about, where was it? Shoot.
Do I have it up on the screen right now? Because this was for me, this was a big one. The judge The judge
Yes.
is saying if the ACC loses and the most valuable contracts are found to be not to be enforceable, the ACC loses millions of dollars. How is that not material? Sure, you wanted to uphold the status quo, but why open the door to the risk that you lose the case and lose millions? Isn't that material? And then you tweeted out, this is it right here. It's about to go down.
Yeah.
Basically, to me, I'll say what I think that means, and then, Immaculate, you can go forward. But to me, the judge is like, I don't know. Is he sort of like saying, man, you guys, there's a way out of this without going through all this litigation. That's what my thinking is here. What do you think?
Yeah, he's saying maybe you guys should settle this out of court.
Yeah.
Maybe you guys, because the thing about this is what I've read from others, and my understanding, which could be wrong, is that if he was to have to rule on this, and he was to rule against them, they don't then get to say, okay, well, we want a partial ruling. No, you did nothing. Like, they're risking getting nothing, and they're risking like having the whole grant of rights just be gutted. And not just that, but what they're doing to grant of rights within the entire industry through this case. I think that's what he's warning them right there. Is like, and it was very big. And I read it, what Rohan said, and thank God he's there doing that because he has kind of the lawyer's mind to show us this stuff and how it's going. That was a huge warning. Mm-hmm. And if I was everyone else in the industry right now, you might want to be calling up the ACC saying, "Don't you freaking dare! Don't you freaking dare!" Because that could, as you're seeing in this case, there's a ton of referencing to precedent cases in the past. It's how it goes in these courtroom battles. And if this creates one, this will be used in so many more in the future. And I think that's what he's warning them about is you should really be careful what you're doing here. Because while you're in North Carolina, yay, whatever, it's still a business court. Like, you have gone outside of the boundaries of how you're supposed to go about doing this. And for what? So that you could possibly completely gut the power of gore? Yeah, maybe to get upheld. But if you lose, the risk is so huge. That's what I've been seeing from the game. It was just very interesting to see the judge basically directly tell them that.
Yeah, I've been also following this Michael Waldale from Brentwood Partners, former NCAA Division I athletic director, CEO.
By the way,
what was that?
Sorry to cut you off, but just wanted to let you know that it's going again.
Okay. I just want to show what his thoughts are. He's put out a lot of tweets. We are at a 30-minute break, Michael Waldwood said. This was 3 minutes ago. Thoughts so far. Florida State attorney was not impressive in his presentation. The ACC attorney was a master for the first 30 minutes, then was not able to answer some of Judge Bledsoe's questions halfway through this fun legal session. The winners, the attorneys. Okay. All right, so you're saying that they're back? I thought they were on break here. Hold on.
Well, Ronnie, he started tweeting again. So
okay. All right.
I'll let you go.
Okay. I appreciate it. Call back again if it's, something breaks here.
Absolutely, man. We'll talk to you later.
All right. Thank you, sir. Lawson, the lawyer for the ACC. Lawson is up for the ACC. Lawson says Florida is clear. We are the supremacy of Tech State. We have to look at what the text says and means. Florida State is able to sue and be sued in all courts of equity. You would have to add words to suggest the limitations on sovereign immunity are bound by the state borders.
Call from
Rock and Rant.
Rock and Rant, the floor is yours. How you doing, sir?
I'm doing good. Good morning to you and everyone on the in the community today. So just to kind of stay focused and follow up and kind of be too definitive of Immaculate, I'm right where he is in terms of where this case is, and just definitely just focusing on this motion, not the other things that are coming, which may or may not be ruled dependent upon what is ruled in this first section or separately. And I saw that post that you just listed from that other account you're following. I don't think it matters whether the ACC lawyers were impressive and then blew the questions or FSU's presentation wasn't good. It's all about the word material. This is like the definition of what is ultimately. And there's no interpretation of what that word means from a legal standpoint that millions and millions of dollars of value at risk would not be material that would give the president and the ACC the ruling, the ability to decide to initiate the initial legislation without taking the members' bylaws vote. Like, I just don't see that anyone short of somebody completely in the tank for the ACC, regardless of how good the lawyers are, would rule against that. So if that were to happen, which is what I think is likely to happen based off of all the amazing reporting that the people you're talking about, like Doug, have been doing for us so far, without hearing the tone, which is also sometimes kind of important to be able to hear for yourselves. There's only really there's several remedies that could happen, right? The most obvious one is the invalidation of the lawsuit from the beginning. And I don't know whether the ACC would really have a leg to say, well, we'll just go to the amended one because it's still built on an initial filing that wasn't valid to begin with, even if later on they went back and had the members vote on the amendment. They technically didn't vote on the initial filing that the amendment is based on.
Yeah.
And the other remedies that you could do from a legal perspective, they exist in lesser degrees. They could put, the judge could say, the ACC, you need to go back and take a revote on the original thing, but that's already sort of confused by them having the vote on the amendment. So I don't know whether that holds the same sort of restart button that the ACC or the judge would allow to go. I don't really know that there are damages that they could have awarded to FSU at this point in there, other than like attorney's fees for responding to this initial filing. That he could order them to go back and reform their internal procedures so that this doesn't happen again. But again, that's not really going to solve the main problem that is coming to the case, either from here or now that the judge knows, he has to treat them separately, that there's another pending case from Clemson that's on his docket. So all the show aside, I think the ACC is pretty screwed from inception. Like it's going to be ruled against, barring something that really turns to the next section.
It's sort of like what is that called? Fruit of the poison tree, right? Everything that
Absolutely.
happened after the initial December 21st lawsuit is sort of poison, because of that December 21st lawsuit wasn't acted upon legitimately by the ACC. Rohan Law puts out a tweet. Lawson, the ACC lawyer, Florida subjugated itself and waived sovereign immunity be entering into the ACC contract. The act of joining acted as the waiver according to the plain meaning of the statute. This would contradict the statutory language that requires contractual waivers of sovereign immunity must be spelled out in the specific contract. I think Rohan added that last part. Continue on. I just got to keep everybody updated on the
No, for sure. And I don't even know it started to get past even my non-lawyer scope of understanding business law, but that doesn't, there's still a sovereign. Two sovereigns doing a contract would have to have Doug or somebody else comment on that. That doesn't feel right, but I don't know that that's the case. But I think the interesting thing really ultimately is we've already, I have at least made the assumption that now that this judge was separately assigned the Clemson case, at a certain point in North Carolina, they could wind up coming together in some form within the state. But if it could change everything again from even last night's call and other calls on like the College Football Mafia's show where Doug was on and others yesterday, where if there's not theoretically a case in North Carolina from Florida State because the ACC filed one there. If that gets dismissed, then you're back to there's nothing coming together again because Clemson would then be the only case. ACC against Clemson would be the only case at the moment in North Carolina should this initial one be done. So it's the definition, the legal version of PATC, keep your head on a swivel, because it's all up in the air.
Yeah. And even Michael Waddle here, who gave the ACC lawyers high marks the first 30 minutes, has now been ripping them. Judge asked about citations in North Carolina cases of unincorporated associations. The ACC lawyers, they could not cite any of the past citations. They revert back to common law per general partnerships. And Michael puts up a GIF that has a basketball player taking a 10-foot jump shot and maybe shooting at 7 feet. So
yeah, I mean that just sounds like the his first assessment, and I'm not there, so I don't know, but you can have all the style you want, but if after that the substance doesn't exist and the judge calls you out on it, it hurts your case for sure. There, it also undermines your credibility going forward if you cite case law and then you actually don't know the case law that you're citing.
Yeah.
So
we got
it'll be
another
interesting, but that's my take.
Got it. I appreciate the phone call, Rock and Rant. Call again. Later. I mean, don't. Please call again. All right. During this live show, whatever goes on, whatever happens today. All right, sir.
Absolutely, we'll do. Thanks.
Appreciate it, man.
Bye.
We got another a tweet, Rohan Law. Judge asked point blank, do you have any cases that show members owe any duty to the conference? Cooney says no, but Florida State doesn't have any cases that there is a fiduciary duty. Not good. This is the same as he did it too. Interesting. The judge asked point blank, do you have any cases that show members owe any duty to the conference? Cooney says no. Cooney is, by the way, the lawyer, one of the lawyers, the main lawyer so far in this case for the ACC. So again, I'm doing the best I can to interpretate this. Michael Waddell, again, he started off, he does not have to me, it seems like Michael Waddell does not have a skin in the game for Florida State. He does not look to have skin in the game for Florida State. This is his tweet just a second ago. The last half hour has been a real struggle for the AC's legal team. They came out strong, but have not gained any ground and are not answering Judge Bledsoe's questions. The ACC attorney sits. Florida State attorney now back up for 8 minutes, asked to address ratification points made by the ACC. Back and forth we go. Back and forth we go. Again, I'm just reading you tweets of those who are in the courtroom who are covering this major event court case in Mecklenburg County. I'm not going to be able to add much, but again, we have very smart people in the PATC community. Bobby Davis, thank you so much for becoming a new member, an early peak Cloak and Dagger member. Bobby Davis, you are hereby knighted Cloak and Dagger. Holy smokes. Thank you, Mr. Davis, for becoming a member. Thank you for your generosity, and I appreciate that you are here today watching this live show. We don't know what's going to happen. We're not expecting a ruling today. We're just watching along. I know a lot of people in the chat room understands everything that is being said. I don't. So please be patient with me. But I appreciate you all coming in again. This show today is just going to be a sounding board, right? We're just going to try to gather the information the best we can. Okay. It does look like we're having some technical issues. I do apologize for that. I don't even know if we're up. Hold on, everybody. I'm trying to get everything back here. We had something happen. Hold on. Hold on, everybody. We're almost back. We're almost back. We lost basically everything. Except for it looks like we didn't lose the stream for whatever reason. Okay, looks like crab cakes and football. This might get dismissed today if nothing changes. I do apologize. I'm not sure what happened, but it looks like we are back. You still have audio and video. He tweeted again. The voice is soft. Is my voice soft? Okay. Can anybody hear me? Cam and B, okay, everything's good. Okay, all right. I think we're back. Woo! Okay, here we go. Man, oh man, that was scary. I was about to shut everything down. Okay, here we go. I've missed. I'm behind. Suddenly I'm behind. Suddenly I am behind. Okay. Cooney finishing strong. Cooney is finishing strong. This is the ACC lawyer. Florida State is arguing that North Carolina is a more favorable jurisdiction for the ACC. We are not here because this is more favorable. We are here because it is the right jurisdiction. Mr. King for Florida State gets up with 4 minutes plus additional 4 minutes to address the judge questions. Starts with the ratification issue. And understand it better, the ACC is arguing now that I helped make the ACC's argument for them. And I want to give you the chance to help clarify your position. Okay. King, Florida State's lawyer, addressing relate back argument. The issue is standing authority to sue. If you don't have the authority to sue, you can't. Judge interjects. Before you have authority to sue, you need to have an injury. King is not picking up what the judge is putting down, and he's sticking with the language he's already prepared for. Recycles the same argument from the brief. So what I think what Rohan is saying here is, yes, King, the lawyer of Florida State, is saying that the ACC did not have the authority to sue on December 21st. But the judge is maybe saying here, but before you have the authority to sue, you need to have an injury. What has been the injury to Florida State when they sued on December 22nd? Is that what he's saying? Judge asked King, Florida State's lawyer, about the GAO case again. Judge says there was an injury at the time the first claim was filed there. Then there was a second complaint filed, and so the vote to correct the issue in the second complaint had nothing to do with the standing of the first claim. Judge Bledsoe is trying to lead King to the strongest argument possible to make, that this is a ratification of the initial complaint. And King again missed a chance to say that. Let me say, it is very easy to be critical from the gallery when the bullets aren't flying at you. Judge is going to exceed the time limits because he still has questions. Calling Cooney back up for the ACC to address the ratification of the complaint. And that's the January 12th vote. Cooney tries to allege again that the January 12th vote was approving the claims in the original complaint, not the ratification of the filing of the original complaint. He knows the judge is skeptical of the arguments of the ACC. So he's trying to be clever to distinguish between ratifying the filing of the original complaint and ratifying the claims that were included in the original complaint. So now let me know if I got it all wrong in the PATC chat room, but it sounds like what the ACC is arguing is that January 12th vote, when we actually followed the Constitution of the ACC, we did not do that to ratify the original complaint. We did that to ratify the claims in the original complaint. Yeah, the ratification is the vote. Rohan tweets out again. Again, Doug Rohan, who's been on our show on Big 12 Mafia and other Old and Garnett with VC Noel and everybody else. He's in the courtroom. He's given us the information as it happens. King, Florida State's lawyer. Ratification is not a magic word. It is a constitutional requirement. The vote was required to initiate litigation. No evidence that ratification has any impact on the initial claim that was filed without authority. This is the weakest part of the ACC's case. That first file on December 21st, they had no legitimacy to do it. They did not follow the ACC's constitution. Holy smokes. Michael Waldell. 6 minutes ago, Florida State asked court not to give any deference to the ACC's request. Florida State says the media rights belong to them, not the ACC. Says the ACC's race to the courthouse was a jurisdiction play and the case belongs in Florida. ACC back up for 90 seconds. What happened with the mid-January action was not ratification. The judge will not rule from the bench today on these matters. Now comes the ESPN legal team and the motion to seal. The judge will not rule from the bench today. We didn't think that was going to happen. We think it's going to happen maybe next Tuesday, next Wednesday, next Thursday. And when it happens, we're going to be covering it live here at Peek Around the Corner. Now comes ESPN's legal team and the motion to seal. They want all this stuff sealed. They don't want that media agreement between the ACC and the ESPN to be in public view. They want this thing sealed. Doug Rohan also reporting the same information. Arguments are complete in the first motion. Judge will not rule from the bench. Hopefully no one here expected him to rule from the bench. He knows an order is expected soon. He will do his best. Turning to the ACC's motion to seal. Doug Rohan. Sarah Stone gets up for the ACC to address the court on the motion to seal. ESPN is present. All parties have been briefed. The issue is narrow, tailored to just the ESPN media rights agreement with the ACC. The gore has now been filed and it is public. This is the big one. Remember, this is what Clemson's lawsuit is all about. Really, it is. It's like Clemson basically said there is plain language. There is plain language when read the media agreement between the ACC and ESPN, which is different than the grant of rights. But Clemson, now I know this is the Florida State court. This is the Florida State versus ACC case. But when Clemson filed their lawsuit, they're basically saying in plain language, when you read together the grant of rights and the media agreement between ESPN and ACC, it's plain to see that we, Clemson, if we leave the conference, we take our media rights with us. ESPN wants that media agreement. So does ACC. They want that media agreement sealed. They don't want it. They don't want their trade secrets to be opened up. Florida State and Clemson, they believe they have the Achilles heel within that ESPN and ACC media agreement. It's not in public view. We have not seen it. But Florida State and Clemson, they want to talk about it. They want to talk about it. So we'll see what happens here. This is big. This is big. Let me see if I can... Suzanne says Clemson is loving this. Chad Bracey says, what's going on? Juan Carlos, wow. The grant of rights has been filed and it is public. Okay, let's get back to it. Let's get back to it. Michael Waddell. Chatter around the courtroom is that Florida State landing spot is likely the Big Ten, not SEC. Seems to be some angst between Florida State and ESPN. Taking a shout out to Kirk Herbstreit, hangover from December. Also seems that instead of Tallahassee, the CLT, that these matters could be managed quickly by ESPN and Fox Sports. The chatter around the courtroom is Florida State's landing spot is likely the Big Ten. And we've been reporting that at Peek Around the Corner for quite a long time. The chalk is Florida State going to the Big Ten. That is the chalk. No doors are closed. Florida State, SEC, that could happen, but the chalk has been Florida State, the Big Ten, for quite a long time. Rohan Stone. The things I'm not arguing. Confidentiality. Merits of the breach of confidentiality claim. Whether or not these are public records. No single instance of a media agreement of an NCAA Power 5 school has been made public. VC Knoll, it's classified. Okay, sure, there's no precedent. There's no precedent that a media agreement with a Power 5 school or conference has been made public, but does that mean it should not be made public? I don't know. I do not know. Michael Waddell, who's in the courtroom sitting right next to Doug Rohan, ACC ESPN wants to seal the agreement due to trade secrets being exposed. The ACC attorney talking in circles. Judges asking ACC to complete their point. This is the third ACC attorney who is not fully answering Judge Bledsoe's questions. Florida State is citing public records laws in both states. Again, Michael Waddell started this whole thing. The first 30 minutes of the ACC, the lawyers, Michael Waddell was saying it was a magnificent performance. Since then, it's all gone pear-shaped for the ACC, according to the interpretations of Michael Waddell, who's in the courtroom sitting next to Doug Rohan. Again, Michael Waddell, who just put this out. The ACC attorneys are talking in circles. Judges asking the ACC to complete their point. This is the third ACC attorney who is not fully answering Judge Bledsoe's questions. Holy smokes. Holy smokes. Rohan, Judge Bledsoe understands the Florida State argument that the Sunshine Laws mandate disclosure. Trade secrets exceptions do not apply. Don't apply. What is the ACC's response? Stone says, if we were in Florida, the docs were produced and they dragged ESPN into the court litigation, and if the judge found that the shadow of Sunshine Laws was cast upon the entire ACC, according to Rohan, terrible mixed metaphors, then maybe we would be talking about the Sunshine Law forcing disclosure. But we are in North Carolina, according to Rohan. This is a swing and a miss. The ACC is struggling. The ACC is struggling. Phone lines are open. No, I guess they're not. I'm not sure. Hold on. We had everything go. Yeah, they're open. They are open. 763-260-1333. Give us a call. Give us a call. Talking about this court case. If you have any opinion on what's happening here. Michael Waddell, the ACC says Florida State knew that when they came to Charlotte to review ESPN's agreement that confidentiality was still binding, and yet they willfully breached those conditions using Sunshine Law as reasoning behind their supposed breach. The ACC are saying that Florida State knew when they came to Charlotte. You remember, you got to go to Charlotte. You got to go to Charlotte. You got to go into the vault. You cannot copy whatever in that vault. You cannot take a picture with the camera phone. You can't do anything. You can't even take notes. You got to be able to just go there, read it, remember it. You remember that? When they came to Charlotte, Florida State, to review ESPN's agreement, that confidentiality was still binding, yet they willfully breached those conditions using Florida State's own sunshine laws, reasoning behind their supposed breach. Michael Waddell does not seem all that impressed. Just, let's be honest here, he does not seem to be all that impressed. Holy smokes. Holy smokes. Oh. Stone back. This is Doug Rohan. Stone, the ESPN lawyer here, or ACC lawyer. I don't even remember. It's not up for debate. The agreement between ESPN and the ACC clearly says it was confidential. The ACC can share the agreement with members so long as the member agrees to keep the document confidential. To which Judge Bledsoe jumps in and finishes the sentence of the paragraph. Subject to the laws of the state of the member to whom the disclosure is made. Oh my God! Oh my God! Stone, representing ESPN ACC. It's not up for debate. The agreement between the ESPN and ACC clearly says it was confidential. The ACC can share the agreement with the members so as long as the members agreed to keep the document confidential. And then Judge Bledsoe jumps in and finishes the sentence of the paragraph. Subject to the laws of the state to the member, Florida State, state of Florida, to whom the disclosure is made. Not a good moment. Not a good moment. Even I can figure this out. Not a good moment for the ACC and ESPN. Holy smokes. Holy smokes. Let's get to your comment here. Let's get to your comments. Wow. 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 Not going good. Not going good at all. I'm just going through these comments. ACC's in big trouble. The trade secrets. Boom. Boom it is. Boom it is. Hold on here. I've got messages up the wazoo. Just give me a moment. Give me a moment. Okay, let's get back here. I've got people. I got a lot of stuff coming at me. Hold on. I appreciate everybody's patience. Rohan. Stone's argument is that simply the act of the member putting eyes on the document does not force the disclosure. If that were the case, the member would have to assert that at the initial meeting to North Carolina to review the documents when the ACC warned there could be no subsequent disclosure. The failure of Florida State's counsel to do that acted as a waiver of the sunshine laws requiring disclosure in Doug Rohan. Florida State alumnus, now practicing out of Atlanta, Georgia. It does not. Stone's argument, even for a guy like me, the fat guy from Minnesota, not the brightest bulb in the fridge, but knows where every refrigerator is in every location that I'm at. Even I understand this is the weakest argument I've seen. Stone's just saying, look, if the Florida State, the failure of Florida State counsel to say, wait a second here, the moment we put eyes on the document, That waived the sunshine laws of the state of Florida? Absolutely not. Come on. Come on. Come on. What do we do? Yikes. Yikes. Okay. All right. Okay. All right. I'm sorry, everybody. We've got a lot of things going on here. We got a lot of things going on here. And for some reason, the phones are not working. Um, we'll have to figure that out in a little bit here. Let me we'll get those phone lines working. We'll get those phone lines working. Give me a moment. Give me a moment. Okay. ESPN David Korn is now up at the up here talking. Korn, this is not a difficult question. Your Honor has a lot of tough decisions to make today. This is not one of them. ESPN will suffer harm if the documents are released. ESPN agrees with the ACC. These documents cannot be made part of the public document. ESPN's business is obtaining and negotiating these agreements. ESPN is based on live sports. Live sports is based on these scores. The substance and terms are critical to every renegotiations. Warranties, promise, guarantees are all relevant to other negotiations. Other parties and competitors would love to have access to the agreements to know the specific and non-specific financial and non-financial terms of the contract. ESPN comes out hitting hard. Now, everybody, hold on here. I'm all in a deuce here. We've got a lot of things going on. Hold on. Michael Waddell. Note, when I was on the Big East and CEA television committees working groups, we could only view ESPN agreements in Bristol, Connecticut. ESPN attorney now on stage and greets judge with statement that Florida State stole the documents. And this is an easy question to answer. ESPN, Florida State are not cozy. Yeah, that's, you can say that again. You can say that again. Let me see if I can make these phones work here. Okay, give us a call. See if this works. 763-260-1333. 763-260-1333. We are working through some issues that we had. I think we all, basically almost the whole thing went down about 30 minutes ago. Korn, back again. ESPN lawyer, these are commercially sensitive agreements. No dispute from Florida State that disclosure of the contracts to the upstream market, negotiations with other networks, and downstream markets, other broadcast partners and schools, will cause harm. Judge Bledsoe, has any agreement with any conference been ordered to be disclosed? Korn, disclosed? Yes, but subject to strict protective orders, prevent public disclosures. Korn continues, these are trade secrets. No special sauce required to create a trade secret. ESPN has made extensive efforts to keep the material safeguarded. If there is a disclosure, there is no unringing of the bell. It can't be undisclosed. Last point, the ACC, if they are in breach, does not cause the agreement to no longer being protected. They cannot be penalized by the bad acts of others. Somebody give us a call here and see if the phone lines work. Even if it's a 1-minute phone call, give us a call. See if the phone line works. Lorenzo Haynes says they're grasping at straws. Tony, is Miami's enrollment 16 to 17,000 too small for the Big Ten? No, it's not. Thank you for the super chat, Tony. I appreciate it. No, it's not. It's a private institution. The market is the value that Miami gives. Plus, they are a research university, AAU. They have high academic standards, high accepted rates. You can go through the whole thing. Their research and development expenditures have skyrocketed in the last 10 years. So has Florida State. They both have gone past Nebraska, for just one example. Hey, phone lines are working.
From
Who's this?
Steve-O, must be working.
Steve-O, thank you for calling. The phone lines are working. Okay, we're fully back up. We had something happen about 30 minutes ago. Steve-O, do you want to make a comment, or are we just checking the phone?
I'm just checking it for you.
I appreciate it, Steve-O. Thank you so much.
All right.
Call back if there's something of this case, that interests you or whatever. But I do appreciate you calling, sir.
All right.
Thank you. Okay, phone lines are working. Everything's working. Everything is working. Let's get back to it. Here. Woo! Okay. Here we go. Michael Waddell. Uh-oh, we got the Little General. Little General is on the line.
Call from
The Little General is on the line, the moderator, the one who rules with an iron fist. Mireya Hernandez Garcia Flugar, are you following this case?
Hello, I just called you to make sure your line is working.
Okay, it is working. I do appreciate the phone call. do you have any comments about this Mecklenburg case in North Carolina, Florida State versus the ACC?
Well, I just agree with everything you say, my boy.
That's
And
how it should be. This is the best call I've ever had at Peek Around the Corner. Thank you so much, Little General. I'll talk to you later.
okay, bye.
Bye. All right. Beautiful. Okay, phone lines are working. The moderator called in. Michael Waddell, ESPN attorney, polling his best Mickey Holler impression. The Lincoln Lawyer. By the way, the Little General loves that show, The Lincoln Lawyer, using magic words and secret sauce. May have gotten too cute in addressing the judge with one too many comments. Hamilton approach would have been better. Talk less, smile more. Okay, then we got another post. Holy cow, I'm really screwing up today, I tell you that. Okay, Florida State is back up again, addressing.
Call from
Ryan Thomas.
Ryan Thomas, can you just hold on for 1 second?
Go ahead.
I do appreciate it, Mr. Ryan Thomas. Michael Waddell, Florida State back up again to address the sealing of the ESPN agreement and their argument that records should be released due to North Carolina, Florida Open Record Acts, and those of all states where ACC has member institutions. Says judge must consider these laws. Says the ACC has blinders on per this issue. Mr. Thomas, go ahead. What do you think? How do you think this is going so far?
Well, I just have a question for the ACC and ESPN. I would love to have them explain to me why they believe that a member has a duty to violate the law to make them happy. If Florida and other public records that are there, the members, you don't have a tort if the tort obligation created requires you to violate another tort or to break the law. So, I mean, I clearly, there's that element, and they can say that they waived it, but it seems to me like these schools were restricted in the information they were able to have to make that decision. And, perhaps they were browbeated into that decision. So, I mean, that's not, coercion is not coercion, plays a factor into that. So, I mean, I don't buy that, they willingly signed off and benefited from this article, because I don't think from this, contract, because I don't think they had all the proper information to make the decisions. I think they were misled along the process. And, the other thing I'd like to add, and just to point out to ESPN, I hate to remind ESPN because I deal with intellectual property in my career and I deal with it a long time, but I hate to tell ESPN, predatory business practices and screwing your business partners is not considered proprietary information. Something that's proprietary information is things like, secret formulas, for like Coke, like for example, the Coca-Cola formula, or processes for manufacturing something, or customer list, or developing various things. Those are proprietary information. But withholding information from your partners and tactics of screwing other people and deal making, that's not proprietary information. In fact, that's pretty readily had and known in the public knowledge in the public domain. So I mean, I think this whole thing is just BS spread on the part of the ACC and ESPN, and I hope this stuff gets revealed to the light of day. It's just kind of, this kind of arrogance is just something that annoys me, and hopefully, this will, the elbows will get dropped on on ESPN and the ACC. But I mean, I just want to point out, just because this is a North Carolina judge, yeah, true. I mean, he has the right to interpret Florida law if he needs to, if he wants to. But ultimately, at the end of the day, this judge still has standards, and he doesn't have a duty to the state. He doesn't have a duty to a resident of the ACC, of the ACC. Or in the ACC, he has a duty to the law.
Yeah.
And if
Hold on, I gotta jump in here, Ryan.
Go ahead.
Hold on. I just gotta. We're Mr. Lamb gets up for Florida State. Question starts with a question. If I were to agree that the docs should be disclosed publicly because these are public records and not subject to trade documents exception, would this make the argument that you breached confidentiality mute? Lamb, no. Lamb says the position of the ESPN and the ACC is to ignore public record laws from 7 states. It would be improper for the court to seal something that is public record. Go ahead. I just got to keep up with the tweet. Sorry about that.
No, that's just my point. It's just like, these members don't have a duty to violate the law. They have, first and foremost, the association or the organization has a duty to protect their interests, but it seems like the ACC failed in doing so. And ultimately, their primary duty is to their board of trustees or to the state, governments that fund them. So I don't think ESPN, gets to get away with saying, we get to screw people and keep it secret. Yep. And, the ACC doesn't get away, doesn't get to use that as a cover for their incompetence. But anyway, that's all I have to say, Greg. Keep up the good work and make sure you do, bud.
You got it. I appreciate your phone call, sir. Thank you, Ryan Thomas.
No problem.
Now, the judge has the Clemson complaint on the screen because Lamb is referring to it. Evidence in that complaint that the deal with ESPN and SEC is worth $3 billion. That is disclosure per Lamb, the lawyer at Florida State. That is evidence that ESPN has not made efforts to keep that information secret. That's part of the deal, the $3 billion. But they don't keep that secret. That's what Lamb is referring to in that. Now, I know there was something else here. Hold on. Lamb, we finally get to talk about the magic 10 words. Subject to the law applicable to each such conference member. The reason it matters is because these 10 words apply to 7 states. Those words have to have meaning. Attempting to explain that with mental gymnastics doesn't overcome their burden, the ACC, ESPN's burden. The court should not permit ESPN and the ACC to say, trust us. We have an illustration why this is important. Even in the ACC's, well, I better not say something I don't know quite if it's accurate. Let me get to the next next tweet here. Doug Rohan, Lamb. The ACC has a duty under the ESPN contract to take commercially reasonable measures that amended complaint says reasonable actions. Sir reply says in the declaration of President Ryan adds the language pre-existing authorization. 3 different statements on what is in the language of the agreement. That is why we need to see the documents. We can't trust the ACC to tell us what is in them. Again, they're all referring back to the media agreement between ESPN and ACC. ESPN and ACC wants to keep that quiet, trade secret. It can't be out in public. And Florida State and just most recently Clemson, they want to flip the switch. They want to let that be out in public view. Clemson says there's something in there. There's something in there that is in plain language. In plain language. Michael Waddell. The ACC says Florida State is raising objections to seal as they have repeatedly disclosed privileged information regarding the ACC and ESPN. Florida State argues all contracts and business with Florida State is involved should be open to release based on sunshine laws. Florida State argues these are relics of the past and not currently relevant. 12:39 p.m. First Clemson versus ACC reference. Florida State is showing map of the ACC's geography on 14 screens in courtroom. Florida State now mentioning Virginia President Ryan. This Florida State attorney, Lamb, is doing the best job of anyone so far. Very Daniel Caffey-like, citing specific elements in submissions to the court. Holy smokes. There it is. Friends call me Sean. This case is the blowout. This Waddle guy was pro ACC, but he's been pretty tough on the ACC lawyers since after the first 30-minute mark. After the first 30 minutes, according to Waddell, oh, by the way, everybody, when this is over, Doug Rohan will be a guest of Garnett and Old. He'll be on the Garnett and Old Florida State YouTube channel, VC Knoll. Go to Garnett and Old Florida State, Garnett and Old YouTube channel, college football YouTube channel, Florida State. Doug Rohan will be on there, so give them a listen. Give Garnett and Old a listen. Fantastic YouTube college football YouTube show. Doug Rohan's going to be on there. He is in the courtroom. He knows better than anybody else from somebody who's not a lawyer in the case. So he's going to be able to give you all the great information on Garnett and Old. Fantastic college football YouTube channel. Now, let's get back to my worthless analysis on this. Woo! Okay, let's get back to it. Lamb. Again, the lawyer for Florida State, and one in which Waddell says is doing the best of anybody of the day. Rohan Law tweets out, how are we supposed to defend the case if we stay here in North Carolina? If we can't see the language of the documents? Judge interjects. The ACC and ESPN has already stated in a footnote that they will disclose it with sufficient protective orders. Have you tried to get the docs? Have any discussions been about getting them? Lamb, we need them now. Judge, well, that's a current problem, but seems you should have the results if you just agree to the protective order. Lamb, I can't agree to a partial disclosure. The ACC only gave Your Honor 13 out of the 160 pages. What else is in there? Lamb, again, Florida State, I can't agree to a partial disclosure. The ACC only gave Your Honor, you, Bledsoe, 13 out of the 160 pages. What else is in there? Holy smokes. Holy smokes. Okay. We're trying to keep up. Again, thanks for all you coming on in. We're tracking what's going on in the Mecklenburg County Business Court. Judge Bledsoe, Florida State versus ACC. If you're new to the channel, please subscribe. Smash the like button if you like our content. I appreciate you all coming on in. Lamb, again, Florida State's lawyer. To be bound by a contract, we need to be party to a contract. If we are a party to the contract, it is a public document. The case law is clear. And again, for whatever reason, okay, try that phone call again. Phone lines are not working consistently. My apologies. My apologies on that. I don't know why. I do not know why. Give us another call. I closed it up and very, very odd. Okay.
Call from
JD.
JD, I apologize for that. Our phone is just...
Oh, no worries. No worries.
I don't know what's going on. I don't know what's going on any place. JD, Mr. Semino, the floor is yours. So far, from a layman's perspective, this looks to be going pretty good for Florida State.
Well, I'm going to keep this kind of brief, and if you're on for an extended period of time or come in later in the day, I'll call in because I've got carryover things from the last 2 days that I was trying to wiggle free to where I could call yesterday, but it just took me too long to finish up what I was working on. Anyway, all I want to say, anybody who's questioning the complaining, quote unquote, whining of ACC members, you're getting a front row view today of the behaviors of the conference towards its members.
Yeah.
You know, there is nothing but secrets. The Big Ten, I would say even the current version of the Big 12, and of course the SEC, works to the benefit of its member institutions. The ACC has sought to work for Tobacco Road and then keep the rest of its members in servitude to the conference. That's the way it's been. And if you now that everybody's getting into the document, getting into the secrecy, getting into the behaviors of the ACC, you're seeing it on full display. This isn't just in the last year or two. They get stonewalled at every turn, and anytime there's something that the ACC needs from its members, they create a faux crisis. And it's almost like at gunpoint, force your members to do X, Y, and Z. You know. Anyway, today is fascinating to me.
Yes, it's fascinating.
Today is fascinating to me, but it is even more infuriating.
Yeah.
I'm just ready to get out. People think that FSU is just a malcontent. No. If we go to the Big Ten, you'll be surprised we might be one of your most courteous members, well, except for during football season. We got a trash talk, but you know.
Yeah.
But anyway, let me get off because I'm riveted by your play-by-play. Thank you.
Appreciate it. Thank you. Whoops.
Thank you. Bye-bye.
Man, I'm screwing up. Yep. Thank you. Appreciate it. Great call, JD. Michael Waddell, Florida State asserts the ACC and other conferences keep media contract review at controlled location is to avoid public records law. You think? I worked as a senior administrator in the SEC, Big Ten, and Big East, and we made every effort to avoid being in the target zone of the Sunshine Law.
Call from
DJ.
BJ, the floor is yours. Thanks for calling. What's going on, sir?
Thanks for having me. I just have 2 points, and it'll be super quick.
Yep.
For one, I closed on a house about maybe a few months ago, and I was thinking to myself after, hearing this 13-page of a 160-page document, imagine if I went to my closing, you went to your closing, and the seller only had like 13 of 160 pages and said, hey, the other 147 pages are unimportant, just sign this document. It would be ludicrous. It would be illegal. You know what I mean? I think the whole notion that you can bring 13 pages to a proceeding and cast it off as this is all the other party needs to see is a felony. Should be, in my opinion.
Yeah. Now this goes nicely with what Rohan just tweeted out. Lamb, Florida State's lawyer. It is today 90 days since Florida State has filed the suit in Leon County. ESPN has not filed anything in Leon County to try to make these documents private. This is an example of the lack of reasonable efforts. We are asking you to require ESPN and the ACC to give you, the judge, the entire agreement and allow a paragraph by paragraph analysis of the provisions to determine what is in fact a trade secret. It is improper to seal the documents. Holy smokes. Go ahead, BJ.
That's exactly what I'm thinking. You can't say it's a trade secret and say, this is a trade secret. That has to be, determined by a judge or someone who's qualified, an unbiased, a party. But my second point is the ACC missed an incredible financial opportunity. You have us glued to our computers, at every post. This should have been on the ACC network. It would have got ratings. It would have got tons of ratings.
Yeah.
But maybe I'm being a little facetious, but if this was on the ACC network, I think it would have drew like millions of viewers at least.
Yep. They don't cover this in the way that they're not covering it in the way that PATC's covering it. Let's just put that. We have no strings attached. ESPN has a lot of strings attached, so their loss is our gain, sir.
If ESPN were to cover it, they can put their narrative out there. They can get a hold of the narrative. But since they don't, and ESPN really haven't covered it either, it allows, channels like yours and other channels to get to the truth, which I appreciate. But from a business standpoint, I just think it's horrible that they didn't, broadcast or even mention it, right? So, but anyway, I'm going to get off your line. I just wanted to say those two things. I'll hop back in the comment section.
Appreciate it. Thank you, sir. Great call. BJ, another great call from BJ. Holy smokes. Michael Waddell, who is sitting in the courtroom next to Doug Rohan. Florida State ends with the request to delay bench ruling on sealing ESPN agreement until motion to dismiss is ruled next week. Florida State ends with the request to delay the bench ruling on the sealing of ESPN's agreement until motion is dismissed is ruled on next week. The ACC back up now for 4 minutes and 11 seconds. Arguing seal is needed to avoid Florida court making everything public. ACC feels obligation to protect the data. ACC arguing that request is not to seal already public information, but rather additional stolen data that Florida State new court submission contains. Wow. So, okay, let's get back to Rohan here. Back and forth we go. Doug Rohan, Stone has 4 minutes and 11 seconds to rebuke. Judge immediately asked about the last point of Lamb. The Florida State lawsuit has a lot of the same information on file. The ACC and ESPN has not made any effort to suppress the information. Stone says the material was already made public, so not worth the effort. Judge Bledsoe says you are trying to make this material confidential here, though. Why are you not trying to do it down there in Leon County? Stone replies, addressing these matters in Florida would just draw attention to the sensitive information there and amplify the disclosure that has taken place. Stone is done. Korn next. ESPN has not gone down to Florida. Korn emailed counsel for Florida State and expressed that this might have been a mistake and asked Florida State to talk to them. Florida State never responded. Today is the first time they have spoken. Korn just learned that ESPN's PR department put out an entire complaint themselves in its entirety. Immaculate makes a good tweet. Your Honor, we can't file down there without talking to them first. The ACC can't file down there in Leon County without talking to Florida State first, but we can file a lawsuit against a member of the conference without talking to any members of the conference first. Got it? Very good tweet by Immaculate. Holy smokes. Holy smokes. Amplify, PR department. Woo! Rohan. Doug Rohan. Arguments on the motion to seal are done. Judge will take it under advisement and will rule later. Moving into management conference. The parties have asked the judge to defer the case management conference until the judge rules on the motions. Judge agrees, and that makes sense. Wasted effort to take time to address the schedule if the judge doesn't even have subject matter jurisdiction. Judge Bledsoe speaking. Prior case management orders have ground rules. It is not a binding deadline. It is advisory more than anything else. One issue is do we agree to filing deadlines to be 5 p.m., close of business, or 11:59 p.m., end of day. Parties agree that 5 p.m. is better for avoiding mistakes. Michael Waddell. No decisions today on anything. Both sides made nice arguments and both massively overplayed their hands at times. As a child of divorce, this feels like being the only child of a couple who really does not like each other one iota. Judge Bledsoe and his mirror in Florida are used to this. Wow. Judge asked, Doug Rohan, Judge asked if there are any other motions anticipated. Both parties say no. No need for an order about a stay in discovery. There is a handshake agreement not to engage in discovery. Excuse me, and there's VC Knoll. You guys are killing me. Okay. Okay. That might have been it, guys. That might have been it. Give us a phone call. 763-260-1333. Doug Rohan, Judge Bledsoe anticipates entering his written order as soon as possible. Certainly before the April 9th date of the Florida hearing, thinks he can do that. Wow. Very interesting day. Again, phone line not working. I'm going to have to... You're going to want to hang up, and I'm going to try to open it up. Well, guys, the phone has completely gone wacko on me, so... Unbelievable. And I can't stop it. Well, guys, I guess I'm going to have to shut this live feed down. I cannot shut off the phone. I do appreciate you all coming on in. We We've had phone problems all live show. We'll come back live here in a little bit to cover everything that happened, and we'll just start over. But I do appreciate you all coming in. Until next time, from all of us at Peek Around the Corner, take care of each other.